presidential reference you still want to pursue?
My Lord, I have no contrary instructions, so yes.
Oh, so he wants to continue the presidential reference. So can we read the presidential reference?
So before we proceed, I will request your lordship to read an order.
So before we read, let's start.
An order has been passed for summing of certain record. An order was passed by this honorable court while hearing the presidential reference. When my Lord Mr. Justice Chaudhary was the Chief Justice, an order was passed that certain record is not over here. And those documents are very important for the purpose of deciding this presidential reference. If your lordship would allow me, I'll read that order which was passed.
We will certainly allow you, but at the appropriate time. Let's start with, because none of us were judges when the presidential reference was filed, nor any of us had heard the presidential reference at any stage, nor there is any judge in the Supreme Court who's heard it.
Because
so you may even wonder on the constitution of this bench. It was placed before the committee as, let's not keep speculating on everything. This Chief Justice has relinquished powers and now matters are decided by the committee. Just 2 seconds, just bear with us. What we did was, one senior member did not want to be part of the bench. 2 others was some way or the other related. It was felt maybe they should not be. So just want to allay that. And since the last time it was heard was 9 members, so we tried to do the same, because sparing a lot of judges also takes time. So now if we will start with the presidential reference, and then we will go through all relevant orders. So Attorney General, can we request you to read, since it's your presidential reference, if you can read the presidential reference?
My Lord.
Sir, I'd just like to point out.
We will go, don't worry.
I just want to point, a tribunal was formed, headed by Justice Shafiur Rahman. And
Farooq Saab.
Okay, sir.
Don't mind, but let him start.
Okay.
So actually, to be honest, I've not read it.
Okay, okay, sir. Thank you.
So let's read it.
My Lord. My Lord, this reference comprises of 15 pages.
No, not the facts. What does the President of Pakistan want us to do?
My Lord, if my Lords may kindly turn to order dated 21st of April 2011, that order records the questions which were referred.
So before that, in the presidential reference, it is under which article of the Constitution?
186.
Can you read 186? We do one thing at a time. It's reproduced, I think, in the first page of the presidential reference.
Yes. Clause 1. If at any time the President considers that it is desirable to obtain the opinion of the Supreme Court on any question of law which he considers of public importance, he may refer the question to the Supreme Court for consideration. 2. The Supreme Court shall consider a question so referred and report its opinion on the question to the President.
Okay. Now this is an extraordinary power vesting in the President. And which President had filed this reference?
Sir, President Asif Ali Zardari.
Okay.
On the advice of the federal government, the cabinet.
And what was his tenure in office till?
I believe it was 2008 through 2013.
And after that, how many presidents have come?
2, my Lord.
And none withdrew it?
None of them.
So it's still on our docket?
That's right, ma'am. It's presidential reference number 1 of 2011.
I must regret on behalf of the Supreme Court that it was not listed earlier, because we have a policy now of first in, first out, unless there is some urgency in a particular case. Okay, so would you like to refer to the presidential reference or the order now?
My Lord, I'd like to refer to the order, because that order then captures the questions.
Okay, which order is that?
It's 21st April 2011, 21/4/2011.
21 April.
Isn't there a question in the reference itself?
My Lord, the questions were in the reference also, but
why don't we go to the question of law that was, Mr. Attorney General?
My Lord.
Could we just refer to the question of law raised in the original reference?
My Lord. My Lords, if my Lord may kindly turn to page 16 of the reference.
it finishes at 15.
15. There is no question.
It finishes at 15. 16 is a summary for the Prime Minister.
These were placed. These were placed subsequently. There was an order dated 13, 14 and 18 of, there were orders, several orders of 13, 14 and 18 April 2021, 2011 and on 21/4.
Why you read the reference?
If I can
read the title of the reference, that itself sums up the question. But after a reference ka title,
reference by the President of the Islamic Republic of Pakistan under Article 186 of the Constitution of the Islamic Republic of Pakistan to revisit the case of Zulfiqar Bhutto, reported as PLD 1979, Supreme Court,
original file
53, 38.
File separately some questions, because in the reference the questions are not reflecting in any heading.
My Lord, if your Lordship will allow me, it's a reported matter. The order of this Honourable Court where the questions were framed.
That was
like
the
a
questions framed by the court.
Yes, my Lord.
They are asking what about the questions which you framed in your reference for the opinion of this court?
That is in the reference.
My Lord,
but this Honourable Court also framed the questions
which were framed in the
This Honourable Court also framed the question, and it is a reported
I think, Mr. Attorney General, why don't we just read the entire reference?
my Lord.
And if there are sort of irrelevant or just factual things, we'll skip those.
Well, what happened was that after
let's now
the reference was filed, the questions were subsequently forwarded. I'll skip the language of Article 186 from page 1 and then I'll read. After the restoration of judiciary by the present democratic government, all the institutions of the state are adhering to the constitution and constitutional scheme of trichotomy of power. The judiciary in Pakistan is independent and is playing a proactive role in the cases of public importance. However, some important questions of law remain unanswered, and one amongst them is in waiting since long. This is the case of Zulfiqar Bhutto, reported as PLD 1979, Supreme Court, page 38, decided in Criminal Appeals number 11, 12 and 13 of 1978, who is the founder of the Constitution of Pakistan, first elected Prime Minister of the country, leader of the Third World, Prime Minister of Non-Aligned Movement, founder of the Islamic Bloc, who took the initiative of introducing nuclear technology in the Muslim world. He was convener of the first Islamic Summit in Pakistan, which attracted unparalleled participation of leaders of the Muslim Ummah. Facts. In pursuance of wide-range conspiracy, Shaheed Zulfiqar Bhutto was challaned by the Federal Investigation Agency maliciously to face trial for offences under Section 120B, 302, read with Section 109 and 301, and Section 307, read with Section 109 PPC. The trial was conducted by the Lahore High Court in a highly objectionable manner, and he was judicially murdered. I, as the President of the Islamic Republic of Pakistan, in order to uphold the dignity of the court, supremacy of the Constitution and law, feel constrained to refer a few questions of law which are of paramount public importance and remain yet to be finally determined and answered by the Supreme Court of Pakistan. 1. The law of approver and criminal conspiracies admittedly against the injunctions of Islam, the Holy Prophet, peace be upon him, on the occasion of Hijjatul Wada, pronounced, beware, every culprit is responsible for offense committed by him. Beware, the father is not responsible for the offense committed by his son, nor son is answerable for the offense committed by his father. Admittedly, absence of the accused from the scene of occurrence could not at all constitute personal liability. 2. Earlier, no accused had been convicted and sentenced to death solely on the testimony of an approver. The Honorable Supreme Court of Pakistan has again disapproved the testimony of an approver in the case of Mian Muhammad Nawaz Sharif versus State, PLD 2009, Supreme Court 814, and the law continues to be volatile. The testimony of the approver fails to satisfy both the tests in that he is neither reliable nor his testimony is corroborated in material particulars. 3. Intricate questions of public importance are involved in the matter. None is above accountability in Islam, and more so a qazi. Determination of the question of accountability, or at least a correction of error, amounts to introspective accountability. The democratic system of a country is dependent on the functioning of political parties. Leaders of political parties are repository of public trust and confidence. Their iconic image is an inspirational and motivational force for the followers. In the case of Shaheed Zulfiqar Bhutto, this goes without saying that he was the leader who inspired generations. His charismatic leadership remains a role model for the toiling millions of Pakistan and the Third World, and his appeal for downtrodden is transcending through an annals of history. His totally illegal death sentence and his execution at the hand of tyrant dictators with the help of hand-picked judges is a black spot on the democratic face of Pakistan. 4. Whether the Supreme Court was acting within four corners of law while deciding the appeal by a bench, which was not duly constituted after the absence of two honorable members, namely Mr. Justice Wahiduddin Ahmed, who was shown sick, and the bench chose to proceed in his absence, notwithstanding the fact that he was desirous to join the proceedings, and Mr. Justice Kaisar Khan retired during proceedings. The Honorable Court was legally and morally duty-bound to fill the vacancies. 5. In the case in hand, bias in the minds of judges was floating on the face of the record. A bias in the mind of judge results in vitiation of the proceedings. In the celebrated judgment reported as Asif Ali Zardari and another versus the state, PLD 2001, Supreme Court 568, while dilating upon bias, the Honorable Apex Court held as follows, as under C. A judge may have a personal bias towards a party owing to relationship and the like, or he may be personally hostile to a party as a result of events happening either before or during the trial. Whenever there is any allegation of personal bias, the question which should be satisfied is there in the mind of the litigant a reasonable apprehension that he would not get a fair trial? The est is where there is a real likelihood of prejudice, but it does not require certainty. Real likelihood is the apprehension of a reasonable man apprised of the facts and not the suspicion of fools or capricious persons. 6. Shaheed Zulfiqar Bhutto bitterly complained before the Supreme Court that he had not been given a fair trial in the High Court. As its presiding judge, Mr. Justice Mushtaq Hussain, Chief Justice of the Lahore High Court, and also because the Central Executive Committee of the Pakistan People's Party, presided over by appellant, had joined issue with him in respect of statements made by him, Mr. Justice Mushtaq Hussain, within brackets, in his capacity as Chief Election Commissioner in August 1977. 7. He strongly criticized the observations made by High Court in para 609 to 616 of its judgment, describing him as a Muslim only by name and not living up to ideas or conduct prescribed for Muslim rulers of Islam. Mr. Bhutto stated that this criticism was unjustified and was clear evidence of bias against him. 8. The conduct of the members of the bench holding the trial as well as deciding the appeal is fully demonstrative of bias. Mr. Justice Maulvi Mushtaq Hussain, the then
where is this said? Paragraph 609 to 616?
My Lord, this is in the Lahore High Court judgment, the trial court's judgment.
And the citation is?
My Lord, the citation is PLD 1978.
PLD 1978?
Lahore.
Lahore. Page?
Just bear with me, man. 1978, Lahore, page 3, sir.
523.
523. This was a 5-member bench of the Lahore High Court which was conducting the trial. 8. The conduct of the members of the bench holding the trial as well as deciding the appeal is fully demonstrative of bias. Mr. Justice Maulvi Mushtaq Hussain, the then Chief Justice of the Lahore High Court, Lahore, was known to be biased against Shaheed Zulfiqar Bhutto due to being superseded. The entire legal fraternity and judicial community was aware of the temperament of Mr. Justice Maulvi Mushtaq Hussain, who never concealed his bias and hatred against Shaheed Zulfiqar Bhutto. It will not be out of place to mention here that international community showed complete no confidence in the judgment in issue by defeating Mr. Justice Anwarul Haq for the slot of International Court of Justice, whereas Mr. Justice Dora Patel, one of the authors of dissenting judgment, was going to be elected unopposed, whose nomination had been withdrawn maliciously by the then caretaker government, who had come into power after toppling the democratically elected government of Mohtharma Benazir Bhutto Shaheed. 9.
Who was the Prime Minister in this caretaker government?
I believe it was Mr. Ghulam Mustafa Jatoi.
Are you sure?
1990, if I'm not wrong.
Was there any application made to the Lahore High Court showing no confidence in the then Chief Justice?
The record reflects that several applications were made. 9. Admission of former Chief Justice of Pakistan, Mr. Justice retired Naseem Hassan Shah, on print and electronic media that the decision of Shaheed Zulfiqar Bhutto's appeal was under coercion does not leave any doubt in the mind of a sane and prudent person that it was a judicial murder which was decided and executed by dictator.
On what basis is this statement being made? Where is this admission?
My Lord, there were two interviews which were given by late Mr. Justice, retired Naseem Hassan Shah. One was, I believe, in 1996, but the other more recent one in 2009.
Have you filed the transcript of the interview?
My Lord, I have to file.
To whom?
It was given, it was a television interview which he had recorded, which he had given, and it was also reported in the press.
Which channel or which person?
My Lord, I will have to place it on record.
Mr. Farooq Naik, do you know?
Farooq Naik would have so, but I am aware that there was an interview.
Mr. Iftikhar of Geo News. Mr. Iftikhar of Geo News.
Iftikhar what?
Iftikhar Ahmed, I think so. Iftikhar Ahmed.
Iftikhar Ahmed. Is he still in Geo?
Jawab De program.
Huh?
Jawab De program.
Is he still in Geo News?
He's still, I think he's still there.
And which is the other interview?
Geo mein nahi hai, but he's still here. He's still here.
And which is the other interview? You said there are two interviews.
Yes. There was this rather old interview.
Yes, there was a second interview he had given to an unknown person, जिसमें उन्होंने कहा था कि कहते हैं जो मार्शल लॉ लगता है तो हमें मार्शल लॉ वालों की बात सुननी पड़ती है.
One thing which you may want to make a start, making a note of these things. We would want, we'll pass an order, but we'll want to have these whatever.
We will give the videos as well as the transcripts.
Exactly.
We'll do that. Thank you, sir.
So just make a note of this.
Yeah, I made a note of it.
Right. Did he mention that who has coerced him?
Pardon?
Did he mention that who has coerced him?
Who has coerced him? Yes. Well, he didn't. He just used the word martial authorities. Because the martial law, General Ziaul was in power, and it was all orchestrated. The malicious design was orchestrated by General Ziaul to execute Shaheed Zulfiqar Bhutto.
You mentioned an application being filed by your client, but that was not filed by you, or was it filed?
It was filed by me, I think 2018.
Yeah, Biju filed ki, that's by Mr. Raza Rabbani.
No, my lord, I filed this at CMA in 2018. I'll give you.
Now.
Now, abhi to मैंने कोई file नहीं किया है.
No,
अभी मैंने खाली live stream.
You filed it, or Mr. Raza Rabbani filed it?
I filed it, my lord.
Okay.
And recently I filed an application for live broadcasting.
Okay. I was an impression that Mr. Raza Rabbani has filed.
No, I filed it, my lord. Thank you.
Ji, please continue.
From paragraph 9, my lord. This admission tantamounts to violation of constitutional oath of office, which reads...
No, we skipped the oath.
Naseem Hassan Shah's book, Constitution, Law in Pakistan, pages
Constitution
52 and 53. Kindly read, and everything will be very clear.
Okay. Constitutional laws.
His book is Constitution, Law and Pakistan Affairs.
And Pakistan, and published by?
I do not know, but it's written by former Chief Justice.
Pages?
52. Pages are 52 and 53. And how this judgment was compiled, everything is written.
Mr. Farooq Naik, why are you so far away? We don't want to keep calling upon you or send some junior forward. And we would like this book to also, because he has referred to...
Can you read it?
No, we won't read it now. We'll let us finish the reference, but these things keep coming up, so we'll want to see the actual book. Please proceed.
This admission tantamounts to violation of constitutional oath of office, which reads as under.
So skip the oath, we can move on.
As such, Article 6 of the Constitution of the Islamic Republic of Pakistan is fully attracted in this case. Next para.
Then there is a statement of Naseem Hassan Shah in Nawai Waqt, Justice Anwar Haq is इंतहाई मुश्किल हालात में अजीम फैसले किए Naseem Hassan Shah.
So where are you referring to these things?
This is the 2nd of March 19...
No, this paper book, what is in your hand?
ये मैंने फाइल किया हुआ है.
Okay, it's on the record.
It's on record.
Is there a number to it?
Its number is 57888-2011.
578
CMA 5788 of 2009 and filed on 31st of December 2011.
2011. Thank you.
Kasuri sahab, आप former Chief Justice Naseem Hassan Shah साहब के statement पर rely कर रहे हैं?
उसने अपना स्टेटमेंट
उन्होंने जो स्टेटमेंट
तारीफ कर रहा है जी सिद्दत,
उन्होंने जो स्टेटमेंट्स दी
बल्कि
सुन ले
अपनी किताब में लिखा है, अपनी किताब में लिखा है कि चीफ जस्टिस ने कहा हमें चारों जजेस को एक एक क्वेश्चन दिया कि अपने अपने जजमेंट देखो।
अच्छा, आई थिंक
उन्होंने कंपाइल किया।
नहीं, कसूरी साहब, थैंk you for pointing this out. Attorney General, can you continue reading?
My lord.
Because
paragraph 10. Yes. It is important to point out that in Sindh High Court Bar Association versus Federation of Pakistan, PLD 2009, Supreme Court 789, while dealing with the cases of the judges who had taken oath under PCO, the Honorable Supreme Court at page 805 held as under. The judges of the Supreme Court of Pakistan, if any, the Chief Justice of the High Court, if any, and the judges of any of the High Courts, if any, who stood appointed to the said offices prior to 3/11/2007, but who made oath or took oath of their respective offices in disobedience to the order passed by a 7-member bench of the Supreme Court of Pakistan on 3/11/2007 in CMA number 2869 of 2007 and Constitution Petition number 73 of 2007 shall be proceeded against under Article 209 of the Constitution. The Secretary of the Law Division of the Government of Pakistan shall take steps in the matter accordingly. 11. It is also important to mention that Justice Ghulam Safdar Shah, who wrote dissenting judgment in the Supreme Court, was subsequently witch-hunted and ultimately he had to leave the country in a miserable condition. 12. Whether it was legally justified to award capital punishment to Shaheed Zulfiqar Bhutto in the absence of any evidence worth name and merely on the basis of a totally cooked up and maneuvered story which never stood the test of routine cross-examination. 13. Whether both the Lahore High Court as well as Supreme Court were justified in awarding and maintaining the death sentence to Shaheed Zulfiqar Bhutto on the basis of a so-called threat to complainant which was blown out of proportion. 14. All important cases bearing important questions of law become legal precedents for the time to come, and they are quoted as citations, whereas the case of Shaheed Zulfiqar Bhutto is neither cited nor allowed to be quoted as a legal precedent by the courts of law. It is a judicial murder continuously haunting conscience of independent nation and legal judicial circles and hierarchies. 15. The unconstitutional and illegal ouster of Shaheed Zulfiqar Bhutto by a tyrant dictator and subsequent events was the root cause of initiation of an unprecedented criminal prosecution against deposed Prime Minister Shaheed Zulfiqar Bhutto. It is a matter of record which has been evidenced through the public statements of the cronies of tyrant dictator that he wanted to get rid of Qaeda-e-Awam by all means. The use of judiciary for execution of his malicious designs should not remain part of our legal history, as this country has started treading the path of democracy under an independent and proactive judiciary which has shown its resolve to defeat and foil any attempt to undermine or subvert the constitution of the Islamic Republic of Pakistan. 16. Was it not legal duty of the regime to conduct an independent and fair judicial inquiry into the incident before starting criminal prosecution against Shaheed Zulfiqar Bhutto? 17. Was it safe administration of justice to award capital punishment to an accused of conspiracy for murder against whom the essential ingredients of conspiracy were not proved through reliable evidence? 18. Whether justice can be seen to have been done in this case while the appellant was deprived of his right of appeal before the High Court, being tried directly by the High Court. 19. Had he been tried by a sessions court, the trial judge would have been legally bound to follow the case law developed up to the time of trial, whereas the High Court ignored the same altogether. In this case, up to the time of trial and conviction, there was absolutely no precedent of conviction and sentence of capital punishment on the testimony of a prover. Neither in the judicial history of this country, murder trial of an accused was conducted by the High Court in its original jurisdiction, thereby denying the accused a valuable right of appeal before the High Court. The trial in this case was akin to the trial of Bhagat Singh, who too was tried, convicted and sentenced in Lahore on the testimony of a prover. 20. The judgment is per inquirium. According to Black's Law Dictionary, a judicial decision wrongly made is termed as per inquirium. The very fact that three honorable judges, Mr. Justice Ghulam Safdar Shah, Mr. Justice Dura Patel, and Mr. Justice Muhammad Halim, out of 7 gave a dissenting view, whereas 4 handpicked judges acted under the dictates of tyrant dictator, which makes it imperative for the Supreme Court of Pakistan to re-examine the law on the point of a prover and criminal conspiracy. 11. 21. It has been ruled by the Honorable Supreme Court of Pakistan in the case of Federation of Pakistan and others versus Mia Muhammad Nawaz Sharif, PLD 2009, Supreme Court 284 as below. Law is not a static object. It has to cope with the modern ideas and concepts and the disputes coming before the court for resolution, as the society with its environmental setup is continuously progressing. Law as well as its remedies are also changing with passage of time. 22. The question of bias needs to be revisited by the Supreme Court of Pakistan in the light of its judgment in the case of Asif Ali Zardari versus the state, PLD 2001, Supreme Court 685. 23. It was a split judgment of 4 versus 3. 4 convicting judges, that is Mr. Justice Sheikh Anwarul Haq, Chief Justice, Mr. Justice Muhammad Akram, Mr. Justice Karam Elai Chauhan, and Mr. Justice Naseem Hassan Shah, and 3 acquitting judges, that is Mr. Justice Ghulam Saftar Shah, Mr. Justice Dura Patel, and Mr. Justice Muhammad Halim, which needs to be revisited, especially after the admission of more than one members of the majority view, judges who, as mentioned, supra minced no words in stating that the judgment was given under undue influence exerted by the day. Whereas it is noteworthy to see views expressed by the dissenting members of the bench concerning the evidence of approval, which read as under. As the prosecution case mainly hinges on the evidence of the approver Masood Mahmood, the question arises as to whether he should be believed or not. An overall examination of his evidence has led me to conclude that it is not of the quality on which reliance can be placed. Not only that, it suffers from inherent weaknesses, but also tends to show that he was a man of conscience, which conduct is wholly unnatural in the background of the facts elicited in the evidence. This feature had opened the gate for the argument as to whether the alleged order given to him by appellant Zulfiqar Bhutto to kill Ahmed Raza Kasuri and his own reaction to it amounted to an agreement within the meaning of Section 120A PPC. However, this question has been resolved in the judgment of my learned brother G. Saftar Shah J, and I need not go into it. The High Court has construed the substantial omissions and improvements in his evidence as one of details or omissions of matters which have been brought on record by the public prosecutor by putting specific questions. In my opinion, these omissions and improvements vitally affect his truthfulness, and therefore in resolving it in favor of the prosecution in High Court, the High Court has given an illusory value to his evidence. If I may say so with respect, this was wholly unjustified. For the benefit of doubt in the evidence must in law go to the accused, as that is the elementary principle of criminal jurisprudence. 24. Accused is entitled to fair trial. Justice rushed is justice crushed. No murder in case in Pakistan right from the independence of Pakistan to date has finally been decided in such a short span of time as in the referred case. This unholy and extraordinary haste in disposal of this case also clearly demonstrates bias. 25. It is enshrined in the Constitution of the Islamic Republic of Pakistan that it is one of the prime jurisdiction of the Supreme Court of Pakistan to do complete justice. Article 187, Clause 1. The assumption of original jurisdiction by the High Court for trial of a criminal case is a question of law which needs to be determined by this court, particularly in the light of universally recognized principle and a fundamental constitutional right in Pakistan pertaining to the due process. 26. At the relevant time, the Evidence Act 1872 was in field and Article 164 of Qanun-e-Shahadat order was not on the statute book. The learned High Court, while conducting the trial in hand, did not take into consideration a material fact that prosecution was not in possession of any evidence of conversation between the approver and the appellant. Surprisingly, this fact was also ignored by the Supreme Court while appraising the evidence in appellate jurisdiction. 27. I may make it very clear that coalition government headed by Pakistan People's Party is neither interested in any type of vengeance against anybody, nor the government believes in revenge. However, unprecedented incident of judicial murder of an international face of Pakistan's twice elected Prime Minister and father of the first Muslim woman Prime Minister and the father-in-law of the President of Pakistan, also twice elected and the founder of the largest democratic political force of the Federation, cannot be left unchecked under the dictates of justice, fair play and history, hence this reference.
Now, can we go to the relevant orders that you were referring to?
My Lord. If my Lords may kindly turn to order dated 21st of April 2011.
G.
The President of Pakistan has forwarded the instant reference under Article 186 of the Constitution. The facts.
Who was representing the President of Pakistan?
My Lord, it was Mr. Babar Awan at that time.
He's not representing Mr. Farooq
during the course of proceedings. What happened? He was representing the president
in this case.
No, is he here in the courtroom or no?
He was representing the government at that time. Then his license got suspended.
No, okay.
His license got suspended.
Is he present in court?
No, he's not in court.
Okay.
Now who is representing the president?
The Attorney General.
Attorney General is the
Who
president.
will argue the case?
It is for the government to appoint any counsel.
At that time, the government chose to appoint Mr. Babar Awan as the counsel. And during the course of...
He was not Attorney General.
He was not, man.
Right.
And on 12th of January, while his license was suspended, on 12th of January 2012, while his license was suspended...
No, that's irrelevant.
Another matter.
Okay, now, please proceed. Please proceed. Yeah, I just wanted that clarification. Please proceed.
The facts and the President of Pakistan has forwarded the instant reference under Article 186 of the Constitution. The facts and...
ये जो क्वेश्चन बने ये अब तो कुछ सप्लीमेंट्री रेफरेंस आया है उस रेफरेंस पे तो क्वेश्चन ऑफ लॉ कोई नहीं है बजाय ये कैसे बने ये क्वेश्चन
My Lord, in continuation of ये इससे पहले जो orders हुए थे, if I may read the order, it so appears that the court didn't perhaps made the same observation at that time which my Lord has just made, and then pursuant to that observation, these questions were then forwarded, and they were reproduced in this order. The facts and circumstances.
The picture, see, Awan filed this review, this reference, and for 6-7 days he was addressing this court. People who are friendly to me, they said, Mr. Kusuri, why don't you go there? I said, this can't proceed without me. Let court call me officially. Eventually court called me officially, and I filed about 80 pages.
Mr. Kusuri, I hope you don't mind. They just want to continue with the Attorney General, and then
80 सफ़े का रिमाइंडर दिया जब ने उसको क्वेश्चन बना के उसको पुट करना शुरू किया he lost his temper and court ने उसके 2 साल के लिए उसका लाइसेंस कैंसिल कर दिया because he had nothing to answer. He was fobbling. He was short of answer.
Let us hear the Attorney General Ji.
How is that man sitting?
My Lord, if my Lords may kindly turn to the previous order first.
In a very odd manner.
What is the date of previous order?
18th of April. I think this then answers why the questions were then forwarded and why they are recorded in the order dated. If my Lord may kindly turn to
let's go to this order you are saying.
So first, if I may take you to order dated 18/4/2011 and then to 21st April's order. 18th April's order.
18th April.
Yes. Because this is where I think the question arose, which questions have been referred to by the President. The learned counsel argued the case on the preliminary points relating to the questions of law in terms of Article 186(1) and 2 of the Constitution and needs further time to dilate upon the matter, adjourned to 21/4/2011. Now I'll read 21/4's order, 21st April's order. The President of Pakistan has forwarded the instant reference under Article 186 of the Constitution. The facts and circumstances relating to the questions formulated in the reference need not be detailed at this stage, except noting that Dr. Babar Awan, learned senior advocate for the referring authority, has dilated upon different aspects of the reference, which was received on 2nd April 2011 and was fixed for hearing on 13, 14, and 18 April 2011. Today, that is 21/4/2011, following questions have been forwarded in continuation of the reference, which has already been submitted for the opinion of the court. 1.
This was a supplementary reference.
So they were, I think, they were just forwarded by way of CMA. I believe they were placed on record.
We have not found out.
Could be treated as a supplementary reference. I believe
the questions have been framed and it was submitted subsequently.
Yes,
which are reflecting in this order.
My Lord, and that's what I think the 18th April's hearing was about, where the court was trying to collect the questions.
Let's see what it is.
Number 1, whether the decision of the Lahore High Court as well as the Supreme Court of Pakistan in the murder trial against Shaheed Zulfiqar Bhutto meets the requirements of fundamental rights as guaranteed under Article 4, 1 and 2A, Article 8, Article 9, Article 10 due process, Article 14, Article 25 of the Constitution of the Islamic Republic of Pakistan. If it does not, its effect and consequences. 2. Whether the conviction leading to execution of Shaheed Zulfiqar Bhutto could be termed as a decision of the Supreme Court, binding on all other courts, being based upon or enunciating the principle of law in terms of Article 189 of the Constitution of the Islamic Republic of Pakistan. If not, its effect and consequences. 3. Whether in the peculiar circumstances of this case, awarding and maintaining of the death sentence was justified, or it could amount to deliberate murder keeping in view the glaring bias against Shaheed Zulfiqar Bhutto. 4. Whether the decision in the case of murder trial against Shaheed Zulfiqar Bhutto fulfills the requirements of Islamic laws as codified in the Holy Quran and the Sunnah of the Holy Prophet Sallallahu Alaihi Wasallam. If so, whether present case is covered by a doctrine of repentance specifically mentioned in the following surahs of Holy Quran: Surah Nasa, verses 17 and 18, Surah Al-Baqarah, verses 159, 160 and 222, Surah Al-Ma'idah, verse 39, Surah Al-Araf, verse 153, Surah Al-Nihal, verse 119, and Surah Taha, verse 82, as well as Sunnah Ibn Majah, chapter 71, hadith number 395. What are effects and consequences of doctrine repentance? 5.
What does this mean? Why repentance?
I don't know if it is in relation to
Mr. Farooq Naik, please enlighten us.
I don't know if it is in relation to the statements made by a former judge.
Why repentance?
Maybe
do you have any idea?
To be very honest, no. But what I feel
so
is
if you don't know,
repentance from the complainant side. That's what
from the court comes to the mind. We asked Mr. Raza Rabbani is here. Do you know? Ji? I would not be able to assist you on that issue. Okay. Kasuri sahab, aapko pata hai why the word repentance has been mentioned in this order? Why the repentance in question number 4 or whatever? What are the effects and consequences of doctrine of repentance? Why was this mentioned?
That was a very hard of hearing.
Doctrine of repentance.
तौबा करनी है।
तस्करा तौबा का तस्करा वो दिखा देना इनको जरा। नहीं आप पढ़ लीजिए।
ये है, ये लिखा है ना। What are the effects and consequences of doctrine of repentance? Maybe it was framed. The complainant.
Since he was there, he is the best person to tell us. Do you know why? Do you know why this was written?
बात ये है कि वो तो तौबा तो मैंने देनी थी ना।
जी जी।
कि मैं कहता मैं माफ करता हूँ।
इस रेफरेंस में
तौबा माफी नहीं है।
वो तो दिया तो किसास में आ जाएंगे।
माफ कर देना और तौबा में फर्क होता है।
तो तौबा तो जो है वो तो अल्लाह ताला की ज़ात है देनी होती है।
ठीक है ठीक है। आपको नहीं पता है कोई बात नहीं। Let's say
I'm not because I'm not expert.
No, it's okay. It's
very fair about it.
नहीं, fair enough.
किसी आलम दीन को बुलाइए।
नहीं, fair enough. जी,
whether on the basis of conclusions arrived at and inferences drawn from the evidence material in the case, an order for conviction and sentence against Shaheed Zulfiqar Bhutto could have been recorded. So these are the 5 questions, and then paragraph number 2.
So 1 second, let us clarify one thing. Is this the presidential reference before us to answer these questions?
My lord.
It is?
Yes.
That's your position?
Yes, that's what the order reflects.
Do you disagree with that?
No, not at all. This is the position, my lord.
आगे बढ़ें.
2. In view of the importance of the presidential reference, senior advocates jurists Mrs. Ali Ahmed Kurd, Tariq Mahmood, Abdul Hafiz Pirzada, Fakhruddin G. Ibrahim, Khalid Anwar, Makhtoom Ali Khan, S.M. Zafar, Etazaz Ehsan, Zahurul Haq, and Abdul Latif Afridi are hereby appointed as a Maiki Curai. Ms. Asma Jahangir, President, Supreme Court Bar Association, the Learned Attorney General for Pakistan, and the Learned Advocates General of all the provinces shall also appear and assist the court. 3.
Just 1 minute. So now some of them have passed away.
Yes, my lord.
Mr. Abdul Hafiz Pizada has passed away.
Mr.
Fakhruddin Ibrahim has passed away.
It is 7
SM Zafar.
The lawyers from KP, they have passed away. 2 lawyers.
SM Zafar, yes, he's passed away.
Mr. Latif Afridi and Mr. Zahrul Haq have also passed away.
And Ms. Asma Jahangir.
And Mr. Asma.
My lord,
we are left with, let's see.
Mr. Tariq Mahmood had excused.
Is Mr. Ali Ahmad Kurd present?
Yeah, Kurd sab to maujood hai.
Will you be assisting? Will you be assisting? एक सेकंड
Just one minute.
हमने देख लिया है आप will you be assisting कुर्ता साहब? Yes, will you be assisting or not? Yes, we can't compel in amicus.
Sir, would you be assisting the honorable court?
Yes, sir. If
no, because that's enough. Is Mr. Tariq Mahmood present?
I think he's not well. He's excused himself.
And during the course of proceedings,
Kazuri sir,
on the objection, he had excused.
Mr. Khalid Anwar, is he present?
He also excused himself.
He is?
He excused himself. There's an order of the court on this issue.
Okay, and Mr. Makhdoom Ali Khan?
He's never excused himself. He's not here today.
Not here. Okay, 1 second. So,
and then Mr.
Okay, now we are left with who all? Mr. Ittizaz Ahsan, where is he?
Present on behalf of Mr. Makhdoom Ali Khan. I'm present here on behalf of Mr. Makhdoom Ali Khan. He wasn't sure if your lordship will be issuing fresh notices to the amicus because, as noted by your lordship, many of them have passed away.
Just tell us about Mr. Makhdoom Ali Khan.
If your lordship so desire, he will be present.
It's not our desire. He has been appointed amicus. Try to understand the matter.
My lord.
We cannot compel an amicus. Will he act as amicus or not?
He will be present, my lord.
He will act as amicus.
Yes, my lord.
Okay, fine. Mr. Ittizaz Ahsan.
Associate, basically, he was amicus in this case before.
Please answer the question, don't make a speech. Yes, no.
He was appointed as a lawyer in this case later on in 2012. If you see
yes, no.
No, sir, because Mr. Farooq Ashnaik has instructed him not to appear in the court after.
Yes, no.
No, sir. No, sorry, not as a amicus, but he was lawyer in the last. If you see the last order.
Have you asked you a long speech? Try to be brief. He doesn't want to come. Okay, fine. Now we're left with only 2 amicus then. One is Mr. Makhdoom Ali Khan, one is Mr. Ali Ahmad Kurd. And Tariq Mahmood Sahab is not well, you said. So we may also consider appointment of substitute amicus, and we'll take on suggestions on board. Just bear that in mind. Please continue reading.
Meanwhile, let the original record of the trial of Zulfiqar Bhutto's case be requisitioned from the Lahore High Court, enabling the learned counsel for the referring authority to obtain copies of the same if need be. For preparation of arguments, copies whereof shall also be supplied by him to all the above learned advocates. The office is directed to put up a note for constituting a larger bench.
Then the larger bench was constituted?
My lord.
Any significant order that we need to read?
My lord, there was one order.
One order I would like to.
We'll come to you, Mr. Farooq. Relax.
Okay.
My lord, there is this one order which related to, this is 3/5/2011.
3/5/2011. 3/5, not 2/5.
3/5.
G.
My lord.
3/5 पढ़िए
जी. Dr. Babir Awal, learned senior ASC, has addressed arguments at a considerable length, making reference to a number of documents to assist the court for the purpose of answering the questions framed in the reference. The learned counsel has also.
In general, we just have 2nd of May, not 3rd.
3rd of May, sir.
No copy of order dated
3/5/2011.
There is a 2nd May, and after 2nd May it was adjourned to 3rd May, and then
we just don't have the order.
No, you don't have
2/5 hai, but the main file I have. So what we need to do also is make a copy of the entire order sheets.
दूसरी फाइल है.
दूसरी फाइल है कह रहे हैं.
ब्लू फाइल देखें.
Different file है.
चलिए पढ़ लेते हैं. Let's hear.
I'll read out slowly.
Yes, please
read out slowly.
वो निकलवा लीजिए 3-5 वाला जजेस के लिए, आप लोग भी निकालना है जी।
अब स्टोरी में जरा पढ़ूंगा,
प्लीज रीड इट
जी। The learned counsel has also moved an application, contents whereof are reproduced herein below, that the in charge of police station Ichra, Lahore may be directed to produce the entire record along with register number 9 in respect of case against Mr. Zulfiqar Bhutto.
One second, Mr. Attorney General, just a second. We just found the order.
My lord.
There's a separate file with all the orders in it. So just a second.
Yes.
And page 32 पे जी यू रीडिंग फ्रॉम द सेकंड, पूरा ही पढ़ लेना डॉक्टर बाबर रवान
जी। Dr. Babar Rawan, learned senior ASC, has addressed arguments at a considerable length, making reference to a number of documents to assist the court for the purpose of answering the questions framed in the reference. The learned counsel has also moved an application, contents whereof are reproduced herein below, that the in charge police station Ichra, Lahore may be directed to produce the entire record along with register number 9 in respect of case against Mr. Zulfiqar Bhutto, former Prime Minister of Pakistan, in order to establish that the case was consigned after due investigation and on whose directions the same was reopened. 2. That the above request is made in the interest of justice. Next para. We consider that the production of the aforesaid record is just and proper during the hearing of the case. Therefore, the learned Advocate General Punjab is directed to procure the same in safe custody and produce it before the registrar, which will be examined in accordance with law. I can skip the next para. Qazi Muhammad Ashraf, learned senior advocate, has joined the proceedings as amicus. The office is directed to facilitate him. And
when is Mr. Qazi Ashraf present?
He's not present today.
So he was another amicus.
Yes, my lord. He was, and he appeared also a few times before this.
He's well.
He's well. I met him yesterday in the High Court.
And
he's okay. He's well. He's hard of hearing. He's hard of hearing a little bit.
प्रैक्टिस कर रहे हैं इतना?
जी प्रैक्टिस कर रहे हैं, मगर उनके अब जरा क्या कहते हैं थोड़े से
कराची वाले काजी
कराची वाले काजी.
Okay, I know.
कराची वाले.
ठीक.
जी.
Any other order you would like?
Next following order, because this was the record of the police station. 4th May. Dr. Babar Rawan, learned senior ASC, has addressed arguments and reads out various documents of league order sheets of the High Court. 2. Khwaja Haris Ahmed, learned Advocate General Punjab, stated that the record of investigation of FIR number 402/1974 initially conducted, wherein the case was consigned on 1/10/1974, being untraced, has not been made available. However, it is pointed to him that normally 4 copies of the police record are prepared. Therefore, further efforts should be made to locate the relevant record. 3. Secretary, Ministry of Law, has produced copies of certain notifications which we placed on record. Now, the next order, 5/5/2011. Dr. Babar Rawan, learned senior ASC, continued arguments in support of his contention, during the course whereof he prominently made reference to the proceedings conducted after the dismissal of the review petition until the execution of sentence of death awarded to Mr. Zulfiqar Bhutto. Second para. In the meanwhile, Khwaja Haris Ahmed, learned Advocate General Punjab, has been called upon to explain as to whether the original record of FIR number 402/1974 registered at police station Ichra, Lahore, has been traced or not. As already observed, we consider it prima facie essential to understand the case from the record maintained by the police up till 1st September 1975, when reportedly it was consigned to record as untraced, but subsequent thereto, on the basis of some inquiry, which was entrusted to P.W. Abdul Ahad in respect of conduct of FSF personnel, investigation was started, during the course whereof investigation of FIR number 402/1974 was revived. And in the meanwhile, Masood Mahmood and others started making incriminating statements, etc. in the case. He has explained that in spite of best efforts, record has not so far been made available. However, on being asked, he read out the contents of paragraph 8 of the judgment of the Lahore High Court, reported as PLD 1978, Lahore 523, as well as the relevant...
So the record was found or not found?
My lord, this original...
Rather than reading all these orders, just tell us in a nutshell, was it ever found or it's still untraced?
So this is, my lord, the original record from the police could not be found.
Untraced?
Ji.
Okay, so why read the rest of the order? Anything significant?
इसमें ये हुआ कि इसमें जो उसकी जो कॉपीज थी
सर मैं बताया अचरा का रिकॉर्ड आ गया हुआ है
नहीं वो जो आया है वो एफआईए की जो केस डायरीज थी वहां से आ गया वहां से आ गया
तो 3 बंडल्स हैं उसके 3 बंडल जो पुलिस के 3 बंडल
ओके जी जी इज रिकॉर्ड
फाइल नंबर 6 7 and 21
पुलिस की 3 फाइल आई हुई हैं चलिए ठीक है so why you telling us all this then
well we need not need
no, tell us some relevant stuff
my lord after this there were the arguments so the only thing which was left perhaps was the record of the complaint if I gathered it correctly.
Mr. Attorney General, I just have a question before we come to the question of law under 186 and legal maintainability argument. As a matter of fact, could you tell us when the judgment was passed? Was the Constitution in abeyance at the time?
When the judgment was passed, yes, the Constitution.
At that time, could you give us a little background at that time? What was the political dispensation like at that time?
My lord.
When was in abeyance? Were there any appointments made during that period? That period needs to be understood when the judgment. No, 79. Either the trial period, maybe the whole thing. When it started, what was the political situation? Was the Constitution in abeyance at that time? Was there a constitutional deviation at that moment when this entire process took place? As a matter of fact, we still come to the question of maintainability, which is very important, which you have to answer. But as a matter of facts,
my lord,
maybe you want to put it together.
Ji. My lord, on the night of 4th and 5th July 1977,
we would like to see the notification, everything you see in front of us, part of the record.
ये नोट कर लीजिए बाद में you can provide them later. Please continue.
Another order. So there is another order I was requesting attorney.
Please, which is the other one? Just tell us or you can read it. Which is the relevant ones? Orders. Let's read them.
This is an order dated 12th May.
12th May of which year?
2011.
You see, the precise question is, I'll rephrase it again for the Attorney General, maybe you want to put a file or a paper book on, that the entire trial going up to the Supreme Court was during a period when Constitution was in place, or was it not the case?
Yes.
Was there any constitutional deviation during this period when this entire case took place? That's all I want to know.
Yes. So the country was under martial law.
Sir, if your lordship would allow me,
I think we can take judicial notice of the fact that
the country was under martial law up
but I just want the dates and
but be precise. What my brother is saying. 12th May you wanted to read.
Order dated 12th May 2011. May I read, my lords?
12th May
49.
12th May. From the perusal of record, it has transpired that after imposition of martial law on 5th July 1977, the criminal case against late Zulfiqar Bhutto, which stood consigned, was revived. It appears that in the meanwhile, a private complaint was also filed on behalf of the family members of late Nawab Muhammad Ahmad Khan Kasuri, which initially remained pending on the file of an addition session judge at Lahore. And perhaps in the month of August 1977, the same was transferred to the file of the Lahore High Court. The record so far received from the Lahore High Court through its registrar does not indicate that the record of this complaint has been transmitted. Therefore, the office is directed to requisition the same by sending a letter to the registrar, Lahore High Court, with direction to procure it and forward the same to this court. 2.
So why you read this?
Because this complaint has not come.
Which complaint?
Which is in mentioned.
The record of complaint has
record of the complaint has not come. Now I'll read para 2 also.
A complaint regarding what?
See, complaint was
private complaint.
Private complaint.
There was a private complaint also, which was
the significance.
Because that would show it was an afterthought what was going on. Because
paragraph 2,
private complaint.
Paragraph 2 अगर इजाजत हो पढ़ें clear हो जाएगा.
Okay.
Additionally, 5 different cases, probably under various provisions of the martial law regulations, were also registered against late Zulfiqar Bhutto. During the hearing of the criminal case before the 5-member bench of the Lahore High Court, and their hearing commenced at Court Lakpat Jail from 2nd Feb 1978 by the tribunal headed by Mr. Justice Shafiur Rahman. The Registrar Lahore High Court is directed to procure the complete record of the said cases as well as transmit the same to the court. Sir, this is very important. It was a classified document, but it was declassified by the previous government. And this...
What is this tribunal headed by Justice Shafiur Rahman?
See, a tribunal was formed to look into the veracity of the FIRs, which were registered against late Zulfiqar Bhutto. And the tribunal came to the...
Sorry, I'm pursuant to an order. What was it? How did it happen?
See, an order was passed by the government. A tribunal was formed. And as a consequence whereof, the tribunal formed the opinion and given the verdict that all cases were fake and they exonerated.
Where is that way?
That tribunal, it is still not here. We have got
no. Thank you, Mr. Please. Please, let's. I'm just asking. Can you
private complaint जो है वो that was filed on 31st of July 1977. Complaint was filed and it was transferred.
Where is the record of the tribunal?
It was transferred to the High Court on 30th of September 1977. These are 2 dates.
Where is the record of the tribunal?
This is it was ordered by this honorable
Mr.
court.
Farooq Naik.
Ji, sir.
Please hear me carefully. If you never want this case heard, you can raise these objections. We will go by what is available before us. If something is not before us and you just make a statement, this happened or that happened, if there is some document before us, if you want some document sent for, then you have to be very specific. We will not accept a statement unless that happens. Otherwise, this will just delay the matter. I mean, it's been fixed after a very long time. And if it's not there, it's not there. So if you know how to access it, please tell us. We'll pass the requisite directions to order the production of it. So don't say this is not here, this is not there.
No, my lord. If your lordship allow me, it is written in the order. The Registrar Lahore High Court is directed. He is directed to procure the complete record.
What happened that I'm asking?
Nothing was written to them. I think so. This is what I've not seen any document.
We'll find out.
See, the registrar has to be written to bring the document on the record.
Many years have passed.
Yes.
Now, please, anything else you want to refer to?
And para 3 also, my lord.
Yes, read it.
It is important to note that 3 cases were registered.
These cases
were registered during the pendency of the trial of the murder case by the 5-member bench of the Lahore High Court. Therefore, we consider it appropriate to look into this record as well, because it is also likely to throw light on the facts and circumstances of the reference. 4. The Secretary Ministry of Interior, Government of Pakistan, and the Home Secretary, Government of Punjab, are directed to procure copy of the order passed by the martial authorities under MLR 12 of 1977, along with copies of...
I must stop you now. If you want something specific sent for, please submit an application or give us particulars, this, and who can we direct to send it for? We'll pass such an order.
I'll do it, my lord.
If it is not available, we can't do anything about it.
Your lordship is right. I'll move a proper CM listing the documents which I want to be...
हो गई ना बात. Not only that, just don't say I want this document. You have to say where
they're lying.
Would it be?
Definitely, I've got to show where they're lying.
1 second. Now, anything else in the order that you want to read out?
My lord, just one point, just by way of information. The report, Justice Shafiur Rahman Tribunal report, was the government at that time, both the federal and provincial governments at that time had decided to make them public in 2011. during the course of proceedings of this reference.
So if it's public, then we'll have it?
Yes.
Somewhere or the other?
Gigi, it is duly recorded in paragraph 7 of the order which my learned friend was reading out. Now, the only thing which is not available is the complaint, the record of complaint.
We've understood. Anything further?
That's all. That's all.
Okay. Anything you want to say? No, now I'll just say let me just consult.
Okay.
अटॉर्नी जनरल साहब, ये कंप्लेंट जो आप कह रहे हैं बार बार प्राइवेट कंप्लेंट, इसमें तलबी हो गई थी मुलजम की?
एक तलबी हुई थी, ये पहले सेशंस में हुई थी, वहां से फिर ये हाई कोर्ट आ गई थी, एंड देयर वाज अ 2-member bench of the high court headed by Mr. Justice KMA Samdani at that time, who was seized of the matter on private complaint. अच्छा, जब ये प्राइवेट कंप्लेंट एट वन एंड चल रही थी, तो नीचे जब ट्रायल स्टार्ट हुआ, तो ट्रायल जो है वो हाई कोर्ट ने अंडर 526 अपने पास मंगवा लिया, तो उस वक्त चीफ जस्टिस ने 13 सितंबर 1977 को ये ऑर्डर किया कि ये अब यहाँ चलेगा. सो वो ट्रायल तो उधर चला, फिर वो प्राइवेट कंप्लेंट का पता नहीं लगा कि क्या हुआ वो 2-member बेंच.
ट्रायल के साथ प्राइवेट कंप्लेंट नहीं चली, ट्रायल के साथ मर्ज नहीं हुई एफआईआर एंड प्राइवेट कंप्लेंट.
I have not seen it from the
record. केस के तहत तो फिर कंप्लेंट पे पहले कार्रवाई होनी चाहिए जी.
वो फिर वो रिकॉर्ड में नहीं नजर आ रहा कि
किसी ने ऑब्जेक्शन किया डिफेंस साइड से, किसी ने कहा कि वो कंप्लेंट भी पड़ी है, इसको इकट्ठा रखे और उसको लगाएं पहले.
सर, जब एविडेंस पढ़ेंगे तो पता चल जाएगा उसमें objections लिए गए हैं.
Mr. Attorney General,
when we read the evidence.
Farooq Naik sir, just to get the course right of this matter, I think the first question you have to answer is the maintainability of this review, and we'll come to the facts later of the reference. So you'll have to assist us that under 186, what's the question of law? Because a decision has been given by the Supreme Court, review has also been dismissed. Now, that is the end of the matter. On what principle? आपके जो grounds अभी तक आपने दिखाए हमें, they are talking about as if you are vesting us, your argument is as if Article 186 vests another appellate jurisdiction to review the existing judgments of this court, and all the grounds that so far that we've seen are factual relating to the judgment itself. Now the question is, there is finality attached to the decisions of the court, right or wrong. There could be bad decisions passed by the court, they're final. So the question is, what is the question of law that is for us to give our opinion on when the matter has already been settled by the Supreme Court? So if there is a question, you'll have to articulate. Is it outside the judgment, or because the factual position of the judgment cannot be touched? That's been decided. Review dismissed. That's the end of the matter. And we have no jurisdiction to review second review or look at it through a second appeal. There is no such concept under 186. So 186 at best would be a question of law which you will have to articulate before us. It cannot arise out of the factual position of the judgment because that's settled. We can't look at the facts. You'll have to go outside if at all there is any argument, which I don't see in the ground so far. So that's a difficult question. We already have decisions of this court and of the jurisdiction from India also, which say we can't touch a judgment given by this court and look at it at a policy level. If this happens, then tomorrow there could be references, we keep opening all our judgments. So you'll have to really articulate a point, under what basis do we go into 186, which I would imagine is a difficult one. So please concentrate on the maintainability and the constitutional question, how do we open this matter, if at all, how?
Your Lordship is right. See, under Article 186 of the Constitution, 3 tests have to be met before an opinion is given. It should be of public importance and question of law is involved. And if these 2 tests are met, then the 3rd test is with regard to giving an opinion by this Honorable Court.
Mr. Naik, the 186 says that the question of law is for the court to determine.
Yes.
The question of public importance is for the President to determine. That's for the President. We don't. That's not our problem. Our problem is, what's the question of law? Is the question of law saying this judgment is wrong? Is that a question of law? That is not, to my mind, frankly, speaking for myself, does not constitute a question of law that the judgment is wrong. There has to be more than that, and you'll have to come up with that argument as to what it is. Because if this is the policy, then tomorrow the President can start sending references and start revisiting all the judgments that we've ever given. That will not be a correct way of going about it, and you understand that.
I understand what
so we'll have to come up with, you'll have to come up with something to tell us. What is that novel argument that shows that 186 can be invoked in this matter? So please, this is not easy.
And one thing I would like to add, Attorney General,
decide anything, we have to give the opinion.
Yes, my lord.
Therefore, what has been said till now, that relates to the determination of something by this court. That is not the scope.
It's actually a very serious question. Because when you say it's a question of law, the law has been decided in the judgment. Whatever judgment Supreme Court gives is the law of the land. So this is the law. So what's the question of law? So you can't say this judgment is wrong. It's not a question of law. There has to be something else.
Basically, the entire reference is based on the interview of the judge. Naseem Hasan Shah. That can be a question of law because it was a factual aspect that has been interviewed by some TV reporter after his retirement. And whether this can be a question of law because the entire reference, the crux of the reference is based on that interview. You have to address that, whether it will be converted into a question of law, whatever he has said. Because there were 3 dissenting judges also. He could have been a dissenting judge of that.
My lord.
What was the pressure on him? Why is...
Mr. Naik, let me take you to the real, what you think your question is. Your question is that during a deviation period or any dictatorship, the judiciary is not independent and they don't decide independently. That's a big assumption that you're throwing at us. You're saying that in any martial law, the judiciary is not independent. Hence, this is not a fair trial. You'll have to build a very strong case that how do you break that assumption that the judiciary is independent even during martial law period? And if it's not, what's the evidence? And if it's not, then what is the consequence? But that's a big assumption you're challenging. You're saying that in any deviation period, the judiciary is not independent. That's a big assumption to touch.
I will try to persuade your lordship on this point.
Can I just, before we get into... we're not...
Other things can follow.
Okay, now I think my brethren have raised some very important questions, and you also realize the significance of these questions. We need not tell very experienced counsel standing before us. There are undoubtedly constitutional questions involved, and we need 2 kinds of assistance. One on the constitutional plane, and the other, if you overcome the constitutional plane questions or questions of maintainability, then expertise on the criminal side. So I've noted that there were a number of constitutional experts who are no longer in this world. So I think we need to maybe appoint a few experts on both the matters as constitutional as well as the criminal. We'll first hear the constitutional experts, and then, depending on where we stand, proceed to hear the criminal experts. So I observe a notable constitutional lawyer, Mr. Raza Rabbani. Mr. Raza Rabbani, would you be willing to be appointed as amicus? But we want thorough, we'll extract every ounce from you. It may not be a pleasure by the end of it.
But we need to do something. Courage should be independent.
Ek second. Sorry, why do you keep interrupting?
My case.
But we are appointing an amicus. You have an objection to amicus?
That's what he has raised.
I hope independent hona chahiye. He's asking that.
Should be independent.
If you can propose an amicus, we'll hear your suggestion. Do you have a suggestion on constitutional thing? Mr. Kasuri, now we are asking you. Do you have a named constitutional expert?
Asking this question at random. Let me think it over.
Think. Okay, by all means think. Okay, now I don't know. We would also like, and the expertise on this bench, my colleague on the right is of course expert in criminal law, but it may help us to have another former judge. I don't know if does anyone have an objection to Justice Manzoor Malik being appointed as amicus. We leave it up to his lordship whether he wants to submit something in writing, whether he's agreeable to it or not. If anyone has any objection, please let us know, because I think there is considerable criminal expertise in the person of Justice Manzoor Malik. Would anyone have any objection?
I think it's a good choice, my lord. It's a good choice.
I don't have any objection.
It's a good choice.
If anyone else you can propose, the other day there was a very competent lawyer from Lahore, Mr. Salman Safdar. Do you have any objection? The two names have been given by my colleagues as well. Mr. Javed Khan, who was a former Attorney General, and Khwaja Haris, who was then the Advocate General, who has been in this case as well. So thoughts on that? Anyone has any objections, so we can then have these names?
I think we should get some legal academic also. I think it's high time that we get some academics.
We may add to them when we're later on, if some colleague comes up with another name. So, but if anyone has any objection to these names, subject to their agreeing.
If your lordship would give, like Mr. Kasuri has sought some time, if your lordship will give me a few days, I'll think about it and give the name.
No, do you have any objection to these names? We can supplement
Khalid Javed Khan is a good lawyer, but I've got my doubts his practice on the criminal side.
No, constitutional.
Constitution is okay.
Constitution
is okay.
Like I said, there are two aspects to the case.
Constitution is okay. Good.
So, like you know, Mr. Raza Rabbani, I hope he doesn't mind my saying so. I will consider him a constitutional expert, maybe not a criminal expert. And there is Mr. Shahadat Awan here, who I will not consider. It will be the other way around.
Sir, Khalid Javed Khan is okay as far as the constitution is concerned.
There are a couple of other names also. Mr. Salahuddin Ahmed could be one of them. Mr. Faisal Siddiqui could be another. There could be the son of Justice Fakhruddin Ibrahim, Mr. Zahid Ibrahim. So we want amicus also by, as far as possible, by consent. So let it not be that we have a particular persuasion. We don't want that to come across at all. But we don't want long-winded speeches to be made at the bar. We would expect the amicus to submit things in writing. We will formulate what we think needs consideration, so they can think over them, submit them in writing, and we can call upon them if required, or if they want to add something to it. But we must have something in writing from them.
So right now I can give consent to two names. One is Mr. Justice Retired Manzoor Malik and Mr. Khalid Javed Khan. As far as the other names are concerned, I'll have to consult my client, my lord.
Salahuddin and
the client is sitting very far away.
Both will assist properly.
No. We don't want to. You please address us. Ji.
सर ये दो नाम तो ठीक हैं
ठीक है तो ऐसे भी नाम होना चाहिए जो आपको नहीं पसंद है
वो आपकी मर्जी है that I leave it to your lordship then
otherwise the complainant may object
अब वैसे ऐसे नाम देख लें जिससे आप इस रेफरेंस से फ्यूचर में कुछ अचीव करना चाहते हैं बाकी प्राइम मिनिस्टर्स को सेव करना चाहते हैं ऐसे नाम हो ताकि हमें गाइड करें
my learned brother has mentioned the name of an academic Mr. Yasir Qureshi.
He's at Oxford. He teaches constitutions.
No objection, my lord.
So we won't ask him to come. We can request for
send an
thing through email.
Academic is important to have an academic also. It's very important.
So, to bring that culture into our
flair. It will bring a flair to it.
By the way. Kazuri Sahab, if you want to submit a name, okay. And if anyone else, you can give us a name. Who? Yes, fine. So, अच्छा एक तो ये हो गई बात. The other thing is that there are other family members of the late Zulfiqar Bhutto. they may want to engage counsel. We leave it open for them if they want to do so or not.
My Lord, only yes, there are, but as far as these...
Because primarily we're concerned with the decision affecting their lives as well.
We will ask them and let you know, my Lord.
We will just pass an order, and that order becomes public so they can find out themselves.
Okay.
But we won't hear any person in person, we will only hear through counsel, because these are all highly technical, legal, constitutional issues before us. So we won't grant any personal hearing. The only exception is, and we would request if Mr. Kasuri Sahab wants to engage a counsel, he can do so. He can represent himself. He's a senior counsel as it is. So if this is all right, then what date would you like to propose?
My Lord, after winter recess?
Yes, it has to be after winter recess.
Which winter? This winter, I think.
This winter, not the others.
The only one question, I just remembered. When was the last date of hearing in this case?
My Lord, it was 17th January 2012.
17th?
January 2012.
No, I have an order sheet of 12th November 2012.
My Lord, 12th? What?
November.
Sorry, 12th November, yes.
Not what happened then?
So with that background, they should come up in 2034.
Yes, 12th November.
One second, can you read that order of the 12th November?
Hello. Reference number 1. A request for adjournment is made on behalf of Chaudhry Etizaz Ahsan, Senior ASC, as he's gone to Karachi to attend the funeral ceremony of Mr. Iqbal Haider, Senior ASC, who was passed away on 11/11/2012. The request is allowed and the case is adjourned, date in office. Now, CMA 1993 of 2011, the order dated 17/11/2012, whereby the license of Mr. Babar Awan was temporarily suspended, was passed by 11-member bench, and while entertaining this civil miscellaneous application, such and such by a 3-member bench, it was observed that the request made by the applicant shall be taken into consideration by the requisite bench after its constitution. The office is directed to put up the matter for constitution of the requisite bench to hear the reference as well as this application. And I think this application was perhaps in relation to restoration of his license or something.
Why this case was not listed for 11 years?
My Lord, that is for you to answer. That is for you to answer.
The court.
Sir, we have been making requests.
How very convenient.
Sir, we have been making requests innumerable times for the fixation of this reference.
Think of this last bench comprised of 9 judges.
I would very humbly request this honorable court that the case should be adjourned after election, because it might be used as an election campaign. And I do not want any party to be hurt because of this election, this proceedings. So I very humbly request that the date should be given after election.
Mr. Kasuri.
That's my request. Sir.
No, but I'll just
I may be wrong.
No, you're not wrong. You're not wrong. But let us be fair. This matter, this presidential reference, came to the Supreme Court in the year 2011. A number of presidential references came to the Supreme Court thereafter. They were taken up. There were also then election disputes, etc. So we won't do it. I mean, देर आए दुरुस्त है, मगर अब इसको ये तो नहीं कि मुलतवी करते ही जाएं हम. देखिए नहीं, sorry to say, no.
Law are a politician also, a very senior most politician of this country.
We don't recognize you as a politician.
Member of Parliament way back in 1960.
We don't accept you as a politician, nor do we accept Mr. Farooq Naik as a politician today.
I'm a humble advocate. I'm a humble advocate of this court.
With that, since I'm a founding father of Pakistan Constitution, with that background, I'm requesting you, please.
ठीक है, आप तशरीफ रखें.
In any country, a man who's a founding father of Constitution, just look at America.
तशरीफ रखें.
Their houses.
तशरीफ रखें.
It is in this country that there's no respect.
Mr. Kasuri, please take your seat. Thank you.
Yes. This is my request.
Thank you. So,
sir,
let's put a date in January then. Sorry, you want to add something?
Sir, may I say something?
Please do.
Which I'm morally bound to express my view, sir. Actually, this matter, when this reference was filed before this honorable court under 186 of Constitution, from the very beginning, proceeding till today. There were, I think 7 or 8 proceedings were conducted. Till the time the temporary
15.
15. Yes, I was there. In the first hearing, I still very much remember, in the first hearing, before going to commence the proceedings, that time of the Honorable Bench, presided by the Honorable Chief Justice Chaudhry Iftikhar, they said this matter is of a very, very important matter, and it is not upon the honorable judges to decide the matter. It is required. This bench requires that a panel of amicus curiae be appointed. So, first of all, the order first order was made. That was an appointment of a panel of 10.
We've read it already.
Sir, आप मेरी बात तो सुनिए सर. मैंने feel किया सर. I really felt. मैंने feel किया सर. So
sorry. We don't expect counsel to have feelings.
No, sir.
No. Please. We've already read the order. We've noted the number of amicus who've passed away. We have noticed. We have asked you if you are willing to continue.
Where is it?
No, but feelings keep at home.
Sir, what I felt. वो सारे जितने अमाइकस थे वो सारे एवरी प्रोसीडिंग्स में थे, तो उनमें से कुछ की डेथ हो गई है, मगर दिस ऑनरेबल कोर्ट डिडंट से ए फ्यू वर्ड्स ऑफ सॉरो. मिसाल के तौर पे सर मेरी गदिक में आई एम वन ऑफ द
Kodur Sahab, I must please take your seat now. No, bas that's it. No, please take your seat. I request you. Let us take the case with the seriousness it deserves. No, please. We will not permit this forum to become a talking point or any other reason. No, sorry, this will not be on. If you're talking about the case, yes. If you're talking about something else, please, there is a lot of media here. Go outside and make a statement. Sir, you are free to do so. चलिए अच्छा अब हम ऑर्डर डिक्टेट कर रहे हैं, आप रिक्वेस्ट ही कर सकते हैं ना कि आप तशरीफ रख लें. कसूरी साहब को भी रिक्वेस्ट कर सकते हैं.
थैंक यू सर.
जी शुक्रिया. इसमें वो जो अमाइकस थे वो कौन सा ऑर्डर था अटॉर्नी जनरल?
लॉर्ड, इट वाज 21st of April 2011.
21st of April.
मेन फाइल.
हाँ ठीक है.
इसमें नहीं लगा हुआ 21st में अप्रैल को. It's in the actual file. It starts with
paragraph number 2 of that order, 21st April 2011.
मेरा भी तो था वो आप जरा फाइल देना वापस. अच्छा इसमें है
page 26.
हाँ ठीक, I found it.
Second week. First week में नहीं है. Second week. कुछ लिखो कुछ नहीं. सेकंड वीक तक वीडियोस के अलावा सरद से बताना शॉर्ट में सेकंड वीक
वो उसके अलावा कुछ अच्छा इसमें लिखें. इसमें लिखिए reference number 1 of 2011 was filed by the President of Pakistan under Article 186 of the Constitution of the Islamic Republic of Pakistan, which was entertained by this court. Full stop. A number of hearings took place, but unfortunately the matter was not concluded. The last hearing that took place, the last time when the matter was fixed in court was on 12th of November 2012, but unfortunately thereafter the matter was not fixed in court and has remained pending. Attorney General, can you also let us know the total number of presidential references that have been filed in the Supreme Court under 186? If such information can be, or as far back as you can go. Subsequently, a number of other presidential references were taken up, heard and decided by this court. But this is the oldest pending remaining presidential reference. Is there any other presidential reference remaining before us?
I am not aware of any, sir.
Pending reference. Full stop. It merits determination. Therefore, it merits determination as early as possible. Full stop. Mr. Farooq Naik, Learned Senior ASC, has submitted an application, CMA number 8622-2018, 2011. Bracket closed. Seeking to be heard. Seeking to be heard?
To be implemented as a party and heard.
Party in a presidential reference. Seeking to be heard.
To be heard.
Seeking to be heard. On behalf of. And
be a party to it, my lord. Be a party to the.
To be made a party to the presidential reference. As on behalf, the application has been submitted on behalf of Mr.
Bilawal Bhutto Zardari.
Mr. Bilawal Bhutto Zardari, who is a grandson of the late Zulfiqar Bhutto. Mr. Zulfiqar Bhutto. Full stop. I don't know if we can make a party in a presidential reference. We can certainly hear you, Mr.
Put them on notice and hear them. My lord, party, they can't be made party.
Full stop.
You can put them on notice and hear them.
Mr. Farooq Naik, on a query, Mr. Farooq Naik states, any children of the late Mr. Bhutto alive?
No, my lord.
Children?
Only one daughter. She lives in London.
Okay. Mr. Farooq Naik informs us that there is only one child left, one daughter of the late Mr. Zulfiqar Bhutto still alive, and he has two. How many grandchildren? 4 other grandchildren. 4 okay, na? Altogether 5.
5, 6.
So altogether 5, 6.
5.
And there are other grandchildren. Other grandchildren.
Yes.
Full stop. Accordingly, we put Mr. Accordingly, Mr. Farooq Naik may represent
8 grandchildren. 8 grandchildren. 8.
Okay. No, please. 8 altogether, or 7 plus 1, or how many are there, Mr.
There's myself and my sisters. Myself, my 2 sisters, Farouk.
Altogether 8? Altogether there are 8 grandchildren. Altogether there are 8 grandchildren. Full stop. Mr. Farouk Naik is put on notice to represent Mr. Bilawal Bhutto Zardari, and if any other and if the daughter and any other grandchild of the late Mr. Bhutto wants to be represented, they may engage counsel if they so deem appropriate. See? Okay, full stop. Learned Attorney General for Pakistan. Another learned Mr. Farouk Naik points out that he had moved another application seeking for live broadcast of these proceedings. However, the committee constituted in this regard had already enabled such live broadcast and recommended that it be so broadcast. And we believe it is being broadcast. I don't know if it's working or not.
It's working.
It's working. Justice Mazhar must have seen to it.
So the credit goes to Justice Mazhar
sir.
And Justice Atharullah. So this application has become infructuous and is disposed of accordingly. Full stop. और कोई application है? अच्छा. We, pursuant to order dated 21st, which was the order appointing
1st April 2011.
Learned Attorney General of Pakistan read out the presidential reference. Learned Attorney General of Pakistan was asked whether the said presidential reference has been withdrawn by any successive president, or if the present president or the government wants to withdraw it, and he stated that the presidential reference was not withdrawn, and the present and the government does not want to withdraw it either. Full stop. He accordingly, we asked him to read the presidential reference, which was read in court, and Learned Attorney General also read the certain other orders passed by this court, which he stated were relevant, particularly order dated, which was the questions?
21st April 2011.
Particularly order dated 21st April 2011, which he states that contain the questions which need to be addressed and answered by this court. Full stop. He has also pointed out order dated in the same order, in the same order, a number of Amaiki were appointed, and amongst those, and a number of whom have passed away, and some are indisposed. However, Mr. Ali Ahmed Kurd, one of the amicus, is present in court, and on our query stated that he will assist the court. Full stop. In view of the fact that the matter before us involves significant and important. Sorry. There is representation on behalf of Mr. Makhdoom Ali Khan by Associate Counsel, who states that Mr. Makhdoom Ali Khan is also ready to render assistance. Full stop. Since to fill the lacuna left by amicus earlier appointed, it would be appropriate to appoint further amicus. And in this regard, Mr. We consider that the points that require consideration are both constitutional, are first and foremost constitutional, particularly attending to the scope of powers under Article 186, the scope of Article 186 of the Constitution, and the nature of opinion that could be given. Full stop. Which would include the question of maintainability of the presidential reference. Full stop. Having attended this aspect of the matter, if this aspect of the matter is successfully attended to, the question of the
आपको बताएं कि चीफ जस्टिस ने आज के समाअत का हुक्मनामा लिखवाना शुरू कर दिया है। हुक्मनामा इस वक्त लिखवाया जा रहा है। समाअत हुई है और बेंच का समाअत जनवरी तक मुलतवी करने का फैसला। आपको बताएं कि अदालती मावनीन को नोटिस जारी करके जवाब भी लिया जाएगा। हुक्मनामा जो है वो अभी लिखवाया जा रहा है। आज की समाअत के हवाले से हम आपको अपडेट कर रहे हैं। इस समाअत को बराह रास्त नशर किया गया था। बराह रास्त ये कार्रवाई दिखाई गई। सुप्रीम कोर्ट में जुल्फिकार भुट्टो सदारती रेफरेंस की समाअत बराह रास्त नशर की जा रही है। हुक्मनामा इस वक्त लिखवाया जा रहा है।
Criminal cases. Full stop. In this regard, the name of Mr. Justice retired Manzoor Malik was proposed, and none present, and all present supported his appointment as amicus. Accordingly, subject to his consent, Justice retired Manzoor Malik is appointed amicus, who may elect to either submit, if he agrees to either submit written concise statement
अभी हुक्मनामा इस वक्त आप देख सकते हैं कि लिखवाया जा रहा है। सदारती रेफरेंस पर ये जो समाअत है उसे बराह रास्त नशर किया गया है और समाअत जनवरी तक मुलतवी करने का फैसला किया गया है।
We note that Khwaja Haris was an Advocate General and was associated with this case when it was.
तो आज की जो समाअत जिसे बराह रास्त नशर किया गया बिलावल भुट्टो ज़रदारी की दरख्वास्त पर, उस हवाले से हम आपको अपडेट कर रहे हैं। बराह रास्त जो समाअत हुई आप लोगों ने भी वो देखी, उसका अहवाल भी देखा, उसका हुक्मनामा भी लिखवाया जा रहा है।
Since he is no longer the Advocate General of Punjab, he is also appointed as amicus. Full stop. To gain the assistance of constitutional experts, in addition, on the criminal, to assist on the criminal side, Mr. Salman Safdar is also appointed amicus. To assist on constitutional matters, we appoint Mr. Raza Rabbani, who is present in court and has agreed to his appointment as such, in addition, Mr. Khalid Javed Khan, former Attorney General of Pakistan. Mr. Salahuddin Ahmed and Mr. Faisal Siddiqui.
Mr. Zahid कर लीजिए सर, Zahid को आपने कहा, Zahid Ibrahim.
इन्हों को कर देते हैं.
Zahid Ibrahim को कर देते हैं.
इन्हों कर दें.
Zahid को कर दीजिए.
Zahid को भी कर देते हैं. Mr. Zahid Ibrahim. ठीक है. And Mr. Yasir Qureshi, who is a legal academic based station working at Oxford University, UK, United Kingdom. Full stop. The learned amicus. Acha, full stop. The learned amicus should submit. The learned amicus appointed on the criminal aspect of the matter should attend to such aspect of the case, and those appointed with regard to constitutional determination to attend to constitutional matters. However, if any amicus wants to attend to the other aspect, they will be at liberty to do so. Full stop. One of the presidential reference had referred to an interview of one of the learned judges who sat on the bench of the Supreme, where the matter was earlier decided by the Supreme Court, which resulted in the decision reported in PLD.
The Supreme Court decision was 79, Supreme Court 53.
In Zulfiqar Bhutto v. the State, bracket mein PLD 1979, Supreme Court 38.
53, sir.
53 was
you interim order. 53, and the review mein bhi the. And the review decision therefrom reported as Zulfiqar Bhutto v. State, PLD 1979, Supreme Court 741. और तो कोई नहीं, यही दो थे.
Sir, may I make a submission?
Wait a minute. जुमला कैसे शुरू हुआ? Namely Mr. Justice Naseem Hassan Shah. Full stop. And a review and the interview given by him to Mr. Iftikhar Ahmed, then associated with GEO television, and Mr. Kasuri has also referred to. आपकी CMA कौन सी है, कसूरी साहब? CM has also referred to
CMA 5788 of 2011.
2011. And has also referred to a civil miscellaneous application number 5788/2011, wherein he has filed extracts from the book published by the said judge, titled Constitution, Law and Pakistan Affairs. Italics में कर दें. And published by locally published. ठीक है, ये किताब हमें मिल गई, so आप भी देख लीजिएगा. Full stop. Mr. Farooq Naik, let notice be issued to I've also heard an interview of Justice Zulfiqar Patel.
Justice Zulfiqar Patel ki bhi hai. We can provide the transcript as well as the video. I can do that.
You will do all of these things.
I'll do that. I'll do it.
Mr. Farooq Naik states that there was also an interview given by Justice Zulfiqar Patel, and he will be providing the actual interview on a, what do you call it?
On a YouTube, we'll provide a
CD plus USB.
CD plus USB.
Oblique USB. And provide
a transcript
thereof. Full stop. That notice be also issued to Geo Television because they may have some footage where they did not show. Sometimes if they cut out just important bit, to provide the entire interview that was referred to interview that was conducted by Mr. Iftikhar Ahmed. Correct?
Yes, sir.
So we have covered this.
जी. So इसमें under instructions अगर sir
finding थी ये शफीर रहमान साहब की जो ट्रिब्यूनल की फाइंडिंग थी उसका क्या
सर उसकी वो ट्रिब्यूनल का वो रिपोर्ट मंगवा लीजिए बड़ी इंपॉर्टेंट है वो
आई नहीं है
अभी तक नहीं आई है सर
वो आपने फरमाया कि वो तो पब्लिक हो गई
वो पब्लिक हो गई थी
कैसे पब्लिक भी हो गया
कंप्लेंट का रिकॉर्ड था वो हाई कोर्ट से नहीं आया प्राइवेट कंप्लेंट का रिकॉर्ड
informs us that it is available.
जी वो हो गई थी पब्लिक भी हो गई थी it is only the private complaint record which the Lahore High Court could not send and which hasn't been sent thus far.
उसमें रेफरेंस होगा ना रिपोर्ट में
Mr. Farooq Naik,
रेफरेंस रिपोर्ट में होगा.
If you going to have people standing behind you who do nothing other than show their face,
no sir.
I'm not asking you anything. Mr. Farooq Naik, you make them work.
Yeah, they do work.
No. We're not saying anything.
Okay, I understand.
You make them work.
Definitely, sir.
Okay, so now we are told that report is available.
The report.
The report is available. It was made public by the government.
No, you did the Supreme Court.
Only the private.
I'm appearing on behalf of Supreme Court Bar Association, sir. Notices were sent.
Okay. आसमा जहांगीर साहिबा को दिया था ना?
No, my lord.
नहीं उसमें दिया था ना notice.
She was president.
Yes, my lord.
So what about the president?
Sir, he's going alive.
No, I know you're the secretary. Do you represent the president?
No, sir, secretary. I'm secretary, sir.
No, we know you're a secretary.
President, sir, वो बाहर गए, sir.
अच्छा इसमें मजीद लिख दें. इसमें लिखें. In an earlier order, the president, the Supreme Court Bar Association was also issued notice, and the late Ms. Asma Jahangir was representing SCBA. Full stop. In case SCBA wants to be the representative before this court, let them nominate a counsel of their choice.
अगर पाकिस्तान बार काउंसिल को भी कर दें सुप्रीम कोर्ट बार के साथ.
I don't know. They may not be interested.
दीदी साहब नुमाइंदे करते पाकिस्तान बार काउंसिल के जैसे आपने
रिकॉर्ड है
तो जो भी आ जाएं, we can't force him to come. No, but we can't force him. If he's alive, then he should come. No, we're not. देखिए कसूरी साहब, it's not a question of defending anybody. It's just a question of a presidential reference. If he wants to come before us, certainly we'll hear him. We will not stop anyone unless it's completely irrelevant. Then we won't allow or people coming and using the rostrum to make some sort of a speech. That what we won't permit. We will only hear constitutional and legal arguments, particularly pertaining to the scope of the advisory powers, and if we are satisfied, we proceed further. How to proceed further? Those are aspects which we will consider. जी, इसमें please write further with regard to the matters. We expect to be assisted on the questions which have already been framed by this court, by the learned, by this court. Full stop. Office is directed to send a copy of the reference along with all orders to the learned amicus to attend to the reference and the questions noted in order dated 21 April 2011 include, as well as those mentioned herein. Now, we may add after discussion some or better formulate questions later, but these are just roughly what we are saying. With regard to the criminal aspect of the case, we need to be assisted on the scope of direct criminal trial in a murder case by the High Court, precedents in this regard, the scope of whether there was any objection. How the trial came to be conducted by the High Court, and if there were any objections to the trial being conducted by the High Court, and if so, how the same were attended to, how the objections were attended to. Full stop. We also need to be assisted on the evidence, the significance of the evidence of approvers.
आपको बताएं कि हुक्मनामा इस वक्त लिखवाया जा रहा है चीफ जस्टिस की जानिब से, और हुक्मनामे में लिखा गया कि आर्टिकल 186 के तहत सदारती रेफरेंस दायर कर दिया गया।
Is he not coming forward?
Evidence.
मोटिव पे जी साहब आपने ये भी देखना है कि ये जो इंटरव्यूज होते हैं इनके रीजंस क्या होते हैं, क्या अचीव करना चाहते हैं, मकसद क्या?
Question of motive तो था in the context of motive of the former Prime Minister in regards to the commission of offence.
सर इसमें सबसे इम्पोर्टेंट
But यहाँ पे bias का question था।
बाइस, लीगल बाइस बड़ा इम्पोर्टेंट है सर। लीगल बाइस
ये बताएं शाहिद साहब कि have you read the judgment?
Yes, exactly, sir.
Any criminal issue that you want attended to? Come to the mic.
आपने तो बेसिकली एक अप्रूवर का इशू रेज किया हुआ है कि अप्रूवर के स्टेटमेंट के ऊपर कन्विक्शन रिकॉर्ड हुई है।
Admissibility of the confession, sir, since the person
confession of whom?
Confession of Masood approver, Masood Mahmood.
The comma इसमें लिख दें admissibility or otherwise of the confessional statement of an approver. And the scope and its application to a co-accused.
Exactly, sir.
Okay.
And in the legal bias in the
legal bias will be the constitutional or criminal?
Criminal होगा sir, not constitutional में तो आपने 186 के parameters
legal
set करने हैं.
The question of legal bias, if any. Anything else?
That's it, sir.
Okay.
Sir, इसमें एक जो आपने नाम लिखा है under instructions, फैसल सिद्दीकी का नाम, we object to the name of Faisal Siddiqui as amicus.
Why?
Because of reasons क्या कहते हैं, government's reasons क्या कहते हैं. There are reasons behind it. I don't want to disclose it in the bus. We object to it.
हम देख लेंगे, आपस में डिस्कस कर लेंगे. कसूरी साहब, आपको कोई ऑब्जेक्शन तो नहीं है?
इसमें जो
किसी नाम पे कोई और नाम आपको याद आ गया बता दें. नहीं, कोई और नाम आपको याद आ गया हमें बता दें.
प्राइवेट कंपनी
वो हमने कर लिया उनको. ठीक है,
वो तो आ गई ना.
तो हम we will discuss amongst ourselves.
ठीक है.
Please don't consider this the order.
No.
Wait for the written order.
Right. We know.
It's always good to state what is in our mind.
Written order is the only order.
Anything else you want to say? Or have we covered everything?
आप भूल देना. Salman Sabda का.
We will fix it in the second week of January.
The week starting 15th January.
Sir, another name which we are Mr. Salman Sabdar's name.
वो आ गया.
We object to it.
Oh, you object to it.
How you objection करते हैं? Senator Salman Sabdar. Under instructions I'm stating.
वो तो कोर्ट के फ्रेंड्स होते हैं.
ये आप पर है सर.
No, देखिए, the presidential reference the Attorney General is conducting.
जी.
So
सर हम नोटिस पर हैं तो इसलिए आप दरख्वास्त आपसे ऐसा इस्तदा है।
अच्छा चलें, we will discuss amongst ourselves. We will discuss amongst ourselves.
सब ये आपके लिए नहीं, हम अपने लिए ले आए हैं,
हमारे असिस्टेंट के लिए है। You know, okay, all who come in.
नहीं sir, thank you.
Yeah, one thing we should clarify. I will just it will be in January. We will fix a date in January, and then it will proceed day to day. But I'll have to check with all the judges their availability. So we'll give a date later, what the particular date is, and then please. We just want to finish it. No adjournment.
तो आप करेंगे ना, Constitution asks at 186 पर. Once we cross the hurdle, then we come to the criminality of the case.
Quite a hurdle.
And we want to and one.
आपने hurdle कर दिया है सर.
All briefs, all concise statements and briefs by learned amicus to be submitted. We'll put a date before that. So we should come to court having read those. And you would have also read each other's ones.
Yes, sir. We'll move some CM also for bringing to certain documents, additional documents on record. I'll do that.
No, but
before the date of hearing.
No. Not then. Do it today, tomorrow. We'll incorporate in the order right now.
Okay, sir.
Otherwise, it will get delayed again. If you want to delay it, fine.
No, we don't want to delay it. We want to delay it. We just give us 2 days, sir. Only 2 days.
No.
By tomorrow, we'll do it.
By today.
By tomorrow.
By this evening.
We'll file the CM by tomorrow.
No, CM, you just tell us what documents they are.
Sir,
okay, you want to give a CM by tomorrow.
Sir, 12-11 के अंदर है ना.
Okay, then the order will not be signed till tomorrow.
No, sir. The documents which are mentioned in the...
Mr. Farooq Naik.
Yes, sir.
Please submit it by tomorrow.
Okay.
We will, if it considered necessary, we'll incorporate that in the order today.
Okay.
Otherwise, we'll have to wait for the next date of hearing to pass an order, which will further delay the matter.
We will file.
You've understood it. So tomorrow, file it. So we won't sign this order till today. And if we find it necessary, we'll incorporate those things in the order as well.
By mid-afternoon tomorrow, it will be filed. Before mid-afternoon, my lord.
Anything else?
It is January.
We would want your assistance as well. Thank you, gentlemen.
Thank you, sir.
दरख्वास्त बराह रास्त नशर की गई, हुक्मनामा लिखवा दिया गया और आपने इसको मुलाहिज़ा भी किया और हुक्मनामे में लिखा गया कि बुरसा की जानिब से जो भी वकील करना चाहे वो कर सकता है। बिलावल भुट्टो की जानिब से बराह रास्त नशरियात की भी दरख्वास्त की गई। हुक्मनामे में लिखा गया, ये भी लिखा कि बराह रास्त नशरियात की दरख्वास्त अब गैर मौसर हो चुकी है। तो ये समाअत का अहवाल हम आप तक पहुँचा रहे हैं। चीफ जस्टिस ने आज की समाअत का हुक्मनामा लिखवाया और लिखा कि आर्टिकल 186 के तहत सदारती रेफरेंस दायर कर दिया गया। आखिरी बार रेफरेंस 2012 में सुना गया। बदकिस्मती से ये रेफरेंस उसके बाद सुना नहीं गया और ज़ेरे इल्तवा रहा। फारूक एच नाइक ने बिलावल भुट्टो की जानिब से फरीक बनने की दरख्वास्त दी। फारूक एच नाइक ने बताया कि जुल्फ़िकार भुट्टो की सिर्फ एक बेटी जिंदा है। अदालत को बताया गया कि जुल्फ़िकार भुट्टो के 8 पोते पोतियाँ नवासे नवासियाँ भी हैं। वर्सा की जानिब से जो भी वकील करना चाहे कर सकता है। हुक्मनामे में ये लिखा गया है। चीफ जस्टिस की जानिब से हुक्मनामा लिखवाया गया है। आज की समाअत का अहवाल अगर हम आपको बताएं तो जनवरी तक ये समाअत मुलतवी कर दी गई है और ये भी कहा गया कि चीफ जस्टिस ने कहा कि आपने कोई बयान देना है तो मीडिया पर जाकर दें। और कुर्द साहब, ये केस भी संजीदगी का मुतकाजी है, इसे संजीदगी से देखने दें। अली अहमद कुर्द ने कहा कि कई अदालती मावनीन का इंतकाल हो चुका है, क्या अदालत उनके लिए अफसोस का इजहार नहीं करेगी? जिस पर चीफ जस्टिस ने कहा कि ये केस भी संजीदगी का ही तकाजा करता है, इसे संजीदगी से ही देखने दिया जाए। चीफ जस्टिस ने कहा कि अब आइंदा समाअत जो है वो जनवरी को होगी। अब ये रेफरेंस देर आयद दुरुस्त आयद पर है। चीफ जस्टिस की जानिब से ये रिमार्क्स भी दिए गए हैं और चीफ जस्टिस ने कहा कि उस वक्त भी इलेक्शन मामला थे मगर वो रेफरेंस सुने गए हैं, ये रेफरेंस सुना नहीं गया। ये केस इलेक्शन के लिए इस्तेमाल नहीं होना चाहिए। अहमद रजा कसूरी की जानिब से ये कहा गया। चीफ जस्टिस ने कहा कि कसूरी साहब, इस रेफरेंस के बाद कई रेफरेंस जो हैं वो आए। तो आपको बताएं कि हुक्मनामा इसका लिखवा दिया गया है और समाअत जो है वो जनवरी तक के लिए मुलतवी कर दी गई है। जनवरी 2024 में अब इसकी समाअत होगी। 2012 के ये रेफरेंस का ये मामला है और उस वक्त के सदर आसिफ अली जरदारी साबिक सदर की जानिब से ये जो है रेफरेंस दायर किया गया था और इस पर आज समाअत हुई। इस समाअत को बराह रास्त नशर किया गया और बिलावल भुट्टो जरदारी की जानिब से बराह रास्त नशरियात की दरख्वास्त की गई थी, जिस पर अब हुक्मनामे में लिखा गया है कि बराह रास्त नशरियात की दरख्वास्त अब गैर मौसर हो चुकी है और हुक्मनामे में लिखा है कि समाअत अब जनवरी के दूसरे हफ्ते तक के लिए मुलतवी की जाती है और अदालती मावरीन फौजदारी और आइनी मामलात पर अपनी राय दें। रेफरेंस में एक इंटरव्यू का भी हवाला बनाया गया है। अहमद रज़ा कसूरी ने भी नसीम हसन शाह की किताब का हवाला दिया है। तो ये तो था आज की समाअत का अहवाल, जिसका हुक्मनामा अब जो है वो लिखवा दिया गया है। समाअत अपने इख्तिताम को पहुंची है और अब समाअत जनवरी के दूसरे हफ्ते में होगी, यानी कि 2024 जनवरी के दूसरे हफ्ते में ये समाअत अब होगी और अदालती मावनीन और फौजदारी और आइनी मामलात पर इस पर राय दें। हुक्मनामे में ये भी लिखा गया है, दर्ज किया गया है। तो अदालती मावनीन से भी इस मामले पर जो है आइनी मामलात पर राय तलब कर ली गई है अदालत की जानिब से और समाअत जनवरी के दूसरे हफ्ते तक होगी। अदालती मावनीन फौजदारी जो आइनी मामलात हैं उस पर अपनी अपनी राय दें। हुक्मनामे में ये बात लिखी गई है और रेफरेंस में एक इंटरव्यू को भी हवाला बनाया गया है। अहमद रज़ा कसूरी ने भी नसीम हसन शाह की किताब का हवाला दिया है। जबकि हुक्मनामे में जो लिखा गया हम आपको बता रहे हैं कि फारूक शनाइक ने जस्टिस दुराब पटेल के इंटरव्यू का भी हवाला दिया और फारूक शनाइक इस इंटरव्यू के ट्रांसक्रिप्ट भी फराहम करेंगे, ये भी हुक्मनामे में लिखा गया है। और नसीम हसन शाह का इंटरव्यू फराहम करने के लिए निजी टीवी चैनल को भी नोटिस जो है वो जारी किया जाएगा, ये भी हुक्मनामे में आज बात लिख दी गई है। और इस समाअत को आपने देखा कि इसको बराह रास्त नशर किया गया था। बिलावल भुट्टो की जानिब से इसकी दरख्वास्त दायर की गई थी। समाअत जनवरी के दूसरे हफ्ते तक के लिए मुलतवी की गई है और अदालती मावनीन को तलब करके जवाब भी लिया जाएगा, उनसे मुआवनत भी तलब की जाएगी। बिलावल भुट्टो की जानिब से बराह रास्त नशरात की जो दरख्वास्त दायर की गई थी और उसके बाद ये समाअत बराह रास्त नशर की गई। हुक्मनामे में लिखा है कि बराह रास्त नशरियात की दरख्वास्त अब गैर मौसर हो चुकी है और समाअत अब जनवरी के दूसरे हफ्ते में दोबारा होगी। 2012 का ये मामला और साबिक सदर आसिफ अली जरदारी की जानिब से रेफरेंस दायर किया गया। आज की समाअत का मुकम्मल अहवाल हम आप तक पहुँचा रहे हैं। अभी हुक्मनामे के हवाले से अगर हम आपको अपडेट करें तो रेफरेंस में एक इंटरव्यू का भी हवाला दिया गया। हुक्मनामे में ये बात लिख दी गई है। अहमद रज़ा कसूरी ने भी नसीम हसन शाह की किताब का हवाला दिया है। बराह रास्त आपको लिए चलेंगे निगरान वज़ीर आला पंजाब मोहसिन नकवी मीडिया से गुफ्तगू कर रहे हैं।
क्लियर है, आपको हमारे मसाइल का पता है क्योंकि आप भी
कुछ ना कुछ जरूर करेंगे। दुआ करें इंशाल्लाह कुछ ना कुछ जरूर करके जाएंगे। कुछ ना कुछ जरूर करके जाएंगे इंशाल्लाह। फैसलाबाद के जर्नलिस्टों के लिए जरूर करेंगे, वर्किंग जर्नलिस्ट के लिए जरूर कुछ ना कुछ करेंगे इंशाल्लाह।
लाइसेंस के वाले सर आपने एक ही दफा बहुत ज्यादा फीस ही बढ़ा दी, नए साल से लोग डरे पड़े हैं, रश पड़ गया हुआ है एक दफा से। क्या लगता है वो सीधा ही 1000 रुपये पे ले गए हैं लाइसेंस?
मेरी बात 70 लाख की गाड़ी ले सकते हैं, 1000 रुपये नहीं दे सकते यार, ये तो ज्यादा। मोटरसाइकिल पता है नई कितने की है? 2.5 लाख की। तो 1000 रुपये हुकूमत को दे दें यार। मसला ये है हुकूमत को देते हुए सारा मसला है 2.5 लाख की मोटरसाइकिल, या तो कहना 2.5 लाख की मोटरसाइकिल बिकना बंद हो गई है, उसकी उसी तरह